The Sales of Good Act contains a number of terms that may be implied into the contract. Generally, parties to a contract expect that the terms of the contract will be set out in writing. However, it is possible for the courts to imply certain terms into a contract in certain situations. Breach of an implied or express term gives rise to a remedy, although the nature of that remedy depends on the significance of the term, unless the parties have stipulated a remedy. Law of contract categorizes terms as conditions, warranties, and innominate terms, although the SGA only refers to the first two categories. Whether a stipulation in said contract is a condition or warranty depends on the construction of the contract. This is a question of law for the court, except where the SGA designates a term as a condition or warranty. The court will look at the substance and not the form. In other words, a term is not a condition or warranty merely because it is labeled as such by the parties. A condition is a term of such importance to the contract that its breach entitles the innocent party to treat the contract as discharged. The buyer can waive the breach or treat it as a breach of a warranty. A warranty is a less significant term. Its breach entitles the innocent party only to damages for loss suffered, but does not excuse that party from performing the obligation under the contract. An innominate term is an intermediate term which cannot be defined as either a condition or warranty. Let's now take a look at some implied terms. Section 12, implied condition as to title. The provision in section 12 would be satisfied where the seller agrees to sell the goods owned by another person and the seller arranges for a title. Under section 12, subsection 3 and subsection 4, where the seller contracts to pass only such title as he or a third party may have, there is an implied term that the seller has disclosed all charges or encumbrances before the contract. Section 13, implied term as to description. Where there is a contract for the sale of goods by description, there is an implied condition that the goods correspond with the description. The strictness of this obligation is illustrated by Across versus Ronson case, where the contract for half-inch wooden staves was breached when most of the staves failed to meet this requirement. Section 14, implied term as to quality. Section 14 and 15 contain implied terms as to quality, but they are prefaced with the Calvary temperature principle, and aside from those sections, there is no implied term about the quality or fitness for any particular purpose of goods supplied under contract for sale. Section 14 subsection 2 refers to goods supplied under the contract. So not just the subject matter of the contract, but also anything that is supplied to the goods must be of satisfactory quality. Whether flaws render goods unsatisfactory may depend on the description and the price, and the fact that the defect does not affect the function of the goods is not necessarily decisive. A scratch on the bodywork may render the car unsatisfactory when it is new, although the results may be different when the car is second-hand.